Yes, Mr. Peacock.
Lord, good morning. I appear in this matter with my own friends Mr. Mater and Miss Black for Northern Gas Networks, and my own friend Mr. Yates appears for the respondent commissioners. Your Lordships will have seen this as an appeal from Northern Gas Networks, or NGN, gas distribution company responsible for the gas distribution network in the north of England. The business carried on by NGN was originally spun out of what was National Grid Transco, or NGT, in 2005, NGT itself being the creation of gas privatisation in 1986. Relevantly for present purposes, for a few months in late 2004, early 2005, NGN was a subsidiary of NGT. NGT operates the gas distribution through its regional network of pipes. Some of those pipes are steel. Many of them now are high-density polyethylene, or HDPE. Some of them are still made of cast iron, that being legacy pipework dating back to the late 1880s, the early 1900s. Such iron pipework is prone to corrode and to fracture when the ground shifts or subsides, and flowing gas through iron pipework was long ago identified as potentially harmful because fractured or leaking pipes give rise to the escape of gas, which can then explode if ignited. There were a series of serious incidents in the 1970s and the 1980s meant that the regulatory regime for gas distribution was tightened, so that whilst NGN, like other gas distributors, has a regulatory obligation to keep the gas flowing for homes and businesses, it is now required to replace or to line iron pipework with HDPE pipes. That current regulatory regime requires that iron pipework within 30 metres of premises is to be cured by replacement or lining within a 30-year period, which started in 2001. The Lordships may have seen as reference in the decisions below to the 30-30 programme.
Yes.
And that is it. And we're not here concerned with leaks and ongoing repairs. Those are dealt with by way of ordinary revenue expenditure, and no claims have been made for any further tax relief. We are here concerned only with expenditure under that 30-30 programme. You're also only concerned with expenditure in the accounting years 2007, 2008 and 2009. And the claim is made under the what was then the Finance Act 2001, Schedule 22, which introduced a special relief where expenditure is incurred in remediating contaminated land.
And those provisions are now gone.
They've been rewritten and replaced in the Corporation Tax Act 2009. So the relief is still available.
Right.
Many of the conditions are still the same. Some of the conditions are different.
Right.
The most significant for present purposes was that prior to April 2009, relief was available if the relevant claimant had an interest in or a right over contaminated land. Since April 2009, one now needs a major interest in the land, being a freehold or a leasehold. But in the years in question here, land remediation relief was available if one had a right over the land and one satisfied a series of other conditions.
So companies like the appellant in this case no longer qualify for relief in the
know
vast majority of cases.
Yes, and your Lordships may have noted, but there were the figures for claim
Reduced.
And they reduced in 2009 because for part of that year we could qualify, and for the balance of the year from April 2009 onwards we couldn't. Now, there's a hint in the stance of the respondent commissioners here that the special relief, being relief at 150% of spend rather than 100% of spend, should not be available to this claimant because NGN is only a utility and should be satisfied with relief at 100% rather than claiming relief at 150%. There's a hint or a suggestion that this sort of relief was just not designed to be available to utilities. And we do not accept that. It is quite clear that prior to the change that was made in 2009, one only needed a right over land or a lesser interest in land, lesser than a freehold or a leasehold, in order to qualify for the relief.
This captures other forms of contaminated land as well as the issue we're dealing with.
Absolutely. All forms of contaminated land. I'll show you some of the... I'm going to have to show you the statutory conditions quickly in a moment. But yes, it's all forms of contamination. Now, we are concerned, ultimately, with three questions of statutory construction. But to give you the wider context, the First Tier Tribunal here correctly identifies that there are 6 conditions in the legislative code that must be satisfied before a claim is good. One of those conditions, condition 4, itself has 5 subconditions. The mathematical result being there are in effect 10 conditions that my clients must meet. At the moment we're meeting 5 of them, and we don't meet the other 5 according to either the First Tier or the Upper Tribunal. So the conditions still in dispute are condition 3 is the land in a contaminated state. Parts of condition 4, as this company incurred qualifying land remediation expenditure, or QLRE, and condition 6, which is the expression of the polluter pays principle in this code. Now, for our part, and I don't believe this is controversial, the purpose of the statutory regime is clear. One gets a special relief at 150% of the expenditure as an incentive for a company that takes on and then cures contaminated land. Ultimately, the questions for this court are whether NGN, reading the statutory code purposively, in context and as a whole, does it satisfy the relevant conditions? There is no relevant case law. This is the first time land remediation relief has been considered in this court, as you are going to be asked to address questions that will inevitably have a wider impact beyond the facts of this case. Now, in one sense, it might be sensible to address the conditions in the order in which they appear in the legislation, but the focus in the decisions below, and the reason the Upper Tribunal give for deciding against us, was condition 6. And perhaps to state the obvious, if I can't persuade you about condition 6, we never get to conditions 3 or 4.
Yeah.
Now, that's not to say that the dispute about conditions 3 and 4 don't have wider significance. They do.
Yes, but if you don't persuade us on condition 6, anything we say about any other condition would be obiter.
It would.
And would not bind anybody. And as a general principle, if it's not necessary to decide something, it's necessary not to decide it.
Well, I perfectly understand that. But equally, one shouldn't proceed under the misapprehension that there aren't other people interested in those other conditions.
No doubt there are.
You have the point. There was a procedural issue as to whether the commissioners needed permission to appeal to pursue the dispute about condition 3, and in light of some very recent decisions of the Upper Tribunal, we're not pursuing.
Right.
So there's no procedural issue there.
No procedural issue. Thank you.
We also had below and have reiterated in this court an application to adduce a further witness statement from Mr. Wood to explain the evidential context in relation to condition 4. If it's convenient, I'll deal with that as and when we get to condition 4.
Yep.
So that would then allow me to start with condition 6. as I'm sure the court will be aware, it's a commonly found notion in environmental policy that the polluter should pay for harm caused to the environment. Now, we're not here concerned with imposing a penalty or a tax on a polluter so as to give effect to such a policy, but instead we're concerned with giving relief for companies that take on land and then cure the contamination of that land. But there is a provision, paragraph 12.4, that prevents that relief being available where the claimant is responsible for the problem in the first place.
Or an associated company.
Or a company with which it was connected. And as we'll see in a moment, the rule applies at any time.
Not just at the time of acquisition.
Nope. Nope. The rule is at any time. Now, one does need to see that in context, and I'm going to show you the provision any second, but it is helpful in my submission for you to see how the relief is designed to work, and that also will speed up as and when we get to conditions 3 and 4.
Yep.
So can I invite you to turn up the legislative code? It's in the first volume of authorities at tab 1.
Say first volume, I've only got one volume of authorities.
So,
Well, I'm grateful, so have I. I meant the first tab of the volume. Yes, if I produce a second volume and then spend several hours on it, you're all going to look rather confused. No, it is the first tab of the only volume, and you should find there a printout from the 2007-8 year, and that is agreed to be reflective of the legislation for each of the years. No material difference. And it's Schedule 22 of the Finance Act 2001, headed Remediation of Contaminated Land. Now, just to note, Part 1 deals with deduction for capital expenditure, and we're not directly concerned with Part 1 because this is not capital expenditure, it's revenue expenditure. As you'll see in a moment, we're going to have to look at Part 1 because a lot of the concepts are set out in Part 1 that are then used in Part 2. Now, we are concerned with Part 2, revenue expenditure. Convenient to start with paragraph 12, page 10 of the bundle. This paragraph 12.1, at the foot of that page, this paragraph applies if land in the UK is or has been acquired by a company for the purposes of a Schedule A business or a trade. At the time of acquisition, all or part of the land is or was in a contaminated state. C, the company incurs qualifying land remediation expenditure, that's QLRE. And then over the page, a company is entitled to land remediation relief for an accounting period if the company's qualifying land remediation expenditure is deductible in that period. And then 3, the company's qualifying land remediation expenditure is deductible in that period if it is allowable as a deduction in computing for tax purposes the profits for that period of a Schedule A business or a trade. And then a company is not entitled to land remediation relief in respect of expenditure on land, all or part of which is in a contaminated state, if the land is in that state wholly or partly as a result of anything done or omitted to be done at any time by the company or a person with a relevant connection to the company. Now, just pausing there, paragraph 12 in effect sets out the 6 conditions that are identified in the First Tier's decision at paragraph 39. And I'm going to come back to those in a second. But then just reading on page 11 of the bundle, part 3, manner of giving effect to relief, deduction in computing profits of Schedule A business or trade, paragraph 13 provides that where a company is entitled to land remediation relief for an accounting period, and it is carrying on a Schedule A business or a trade, and it has qualifying land remediation expenditure that is allowable, it may, on making a claim, treat the qualifying land remediation expenditure as if it were an amount equal to 150% of the actual amount. So that's the uplift. But we only get the uplift if we've satisfied the conditions that are found in paragraph 12. Now, we're not interested in paragraphs 14 through to 28. So there's a different mechanic whereby you can, in some circumstances, get a tax credit, and we're not interested in that. Equally, there's a whole section of provisions here dealing with claims by insurance companies, and we're not interested in that either. Paragraph 29 is part 5, artificially inflated claims for deduction. Well, there's an anti-avoidance rule in the schedule, and we're not concerned with that. And then paragraph 30 deals with what happens to the monies raised. It's an internal government thing. So paragraph 31, headed interpretation, contains relevant definitions. So in this schedule, this is page 23 of the bundle, harm means A, harm to the health of living organisms, B, interference with ecological systems, C, offence to the senses of human beings, or D, damage to property. And then 2 definitions down, land means any estate, interest, or rights in or over land. So land there carries its legal definition. What you're looking for is legal interests in or rights over land. You are not obviously there concerned with the physical earth, the land. And that was a problem that raised its head in the first tier, and we'll see in due course how the first tier solved that. And then towards the foot of that page, still in paragraph 31.1, substance means any natural or artificial substance, whether in solid or liquid form, or in the form of a gas or vapour. So natural or artificial, solid, liquid, or gas. And then over the page, paragraph 31, subparagraph 3, for the purpose of the schedule, a person has a relevant connection if you're connected. I'll paraphrase, but the connection required is connected person in the sense provided for it in the Taxes Act 1988. So relevantly for present purposes, a parent is connected with a subsidiary and vice versa. And here NGN was for a period of months a subsidiary of NGT. So we were connected. So if we then, with those definitions in mind, if we go back to paragraph 12, this is page 10 of the bundle, the way the first tier analysed paragraph 10 was to say the first condition is...
Sorry, we're paragraph 12.
Paragraph 12.
Yeah.
Just to identify the conditions.
Yes.
First tier said, paragraph A is the first condition. Did you acquire land? Second condition, was it for the purposes of a trade carried on? That's still in A. A is the first and second conditions. Third condition is in B. Is the land in a contaminated state?
Well, was the land at the time of acquisition?
At the time of acquisition, all or part of the land was in a contaminated state. The fourth condition is qualifying land remediation expenditure. So that's in C, but that's the condition that's broken down into sub-conditions. And then over the page, 12 sub 2, the fifth condition was is your QLRE deductible? And that depends whether the expenditure would otherwise be deductible in computing your trading profits. That's paragraphs 2 and 3 of 12. And then the sixth condition is the barrier provision in paragraph 12.4. Now, the one that has subconditions we'll see in paragraph 2, going back to page 4 of the bundle. This is the definition of qualifying land remediation expenditure, QLRE. I'm not sure whether this is going to matter or not, but for our part at least, that's designed to be a whole phrase. It's a single concept of qualifying land remediation expenditure. And so you have that if you meet the conditions in subparagraphs 2 through 6. So you'll then see that paragraphs 2 through 6 identify 5 subconditions. And the first is that the expenditure is on land, all or part of which is in a contaminated state. The second is that the expenditure is expenditure on relevant land remediation directly undertaken by the company or on its behalf. So you've got another concept there of relevant land remediation, or RLR. Third condition is the expenditure is incurred on employee costs or on materials, or is qualifying expenditure on subcontracted land remediation. Fourth condition is the expenditure would not have been incurred had the land not been in a contaminated state, see paragraph 7. And the fifth condition is the expenditure is not subsidised. So it's that exercise that gives us 10 conditions in total.
And land in this context means the right.
Well, the issue that the first tier faced is that it's quite clear when you're talking about acquiring land that the drafter has in mind a right over or an interest in land. But the first tier recognised correctly that some of these references only make sense if you read land as being the earth. So what the first tier said is, it is rather odd that the only way to make this work is in some instances to read land as...
Well, you can't spend money on an incorporeal hereditament.
My Lord has it. So when it talks about have you acquired an interest in land, it's a legal question. But the other references to land only make sense when you're asking have you spent money on or in relation to the physical earth.
I mean, it's probably a red herring, and I know it was common ground before both tribunals, but I'm not at the moment convinced that the pipes themselves are not land.
Well, for my part, I had long wondered about that. And I'll be candid, I'm not sure whether it leads me anywhere particularly useful, because I think the argument is the same. Equally, I'm not sure whether it leads my learned friend anywhere, but can I take that observation to Lordship, and if need be, we might come back to that.
Yeah. You need to look at a case called Simmons and Midford.
Yeah. And to me, I'm not sure it makes a difference.
No, and I think it was Mr. Yates in the skeleton before the FTT referred to the decision in the Vauxhall and Manchester Ship Canal case, which was about drainage works, which was accepted became part of the land once they'd been installed in the ground. But anyway.
Well, if need be, my Lord, perhaps we can come back to that. But so far, all I've sought to demonstrate is there are 10 subconditions.
Yeah.
10 conditions in total.
There is also, though, the question of harm and contaminated land in 3, just over the page. You were taking us to that?
I'm going to come to that.
Yeah, okay.
So, to flesh out paragraph 2, we need to read on, as my Lord observes. So, paragraph 3 tells us what is meant by land in a contaminated state. Here is an example where the first tier concluded that land had to refer to the physical earth, and that's the first here at paragraph 39. So for purposes of this schedule, land is in a contaminated state if and only it is in such a condition by reason of substances in, on or under the land, so in, on or under the land, such that harm is being caused or there is a possibility of harm being caused. So there are two relevant elements. You need a substance and you need harm or a possibility of harm.
And we're concerned with the possibility of harm.
We are concerned with the possibility of harm.
And my lord's point about land makes more sense if the pipe is part of the land that is contaminated rather than a separate piece of land, and that avoids getting into the argument about qualifying remedial expenditure.
I'm not sure whether it necessarily does, but we just see how we trace it through, because, this is not designed as a criticism, but in retrospect, this is not particularly well drafted. So as to form a complete coherent whole, one has to tread carefully through the whole schedule to make it work. But the Lord is right. Paragraph 3, we're looking at possibility of harm arising by virtue of a substance in, on, or under the land. Relevant land remediation is explained in paragraph 4. So it's relevant land remediation in relation to land acquired by a company means activities falling within subparagraph 2, and if there are such activities, preparatory activity falling within paragraph 4, which satisfies the condition in subparagraph 5. So the activities referred to in 1A are the doing of any works, the carrying out of any operations, or the taking of any steps in relation to the land in question, or any controlled waters affected by the land, or so on. But
The land in question meaning what? The land acquired by a company?
well, yes, it's either the land acquired by the company, or it makes more sense to refer to the land that is in the contaminated state.
Of which the pipes form part.
Yes, and that's where we maybe run up against the debate about whether the pipes form part of the land or not. But just reading on, there's some words that one needs to take account of. So paragraph 4.2 has some pull-out words at the end that even if you've done some works, carried out an operation, or taken a step, that has to be for the purpose described in subparagraph 3. And the purpose referred to in subparagraph 3 is A, preventing or minimising or remedying or mitigating the effects of any harm or any pollution of controlled waters by reason of which the land is in a contaminated state, or B, restoring the land or waters to their former state. So it's prevent or minimise harm or remedy or mitigate the effects of harm. The point I place some reliance on when we get to paragraph 12 is that the drafter here contemplates that you might only minimise harm, or you might only mitigate the effects of harm, i.e. it's not necessarily a complete cure. And then subparagraph 4 sets out the preparatory activities, which is doing of anything for the purpose of assessing the condition of the land. So that tells us you have to have the right sort of action. It's got to be a works, an operation, or a step for a particular purpose set out in sub 3. And then you'll recall from paragraph 4 that you also have to incur the expenditure on employee costs or on materials, or have it subcontracted. Paragraph 5 explains that expenditure on employee costs is on emoluments, national insurance contributions and pension contributions, as you would expect. That's paying the people who do the work. And then there's a provision to deal with what happens if only part of their time is on the work, and we're not interested in that, but there's a scaling that if it's less than 20% it counts as 0, if it's more than 80% it counts as 100, if it's between 20 and 80 then you look at the proportion, but we're not interested in that. So para 5 tells us what's meant by expenditure on employee costs. Para 6, page 7, tells us what is meant by expenditure on materials. Expenditure on materials is attributable to relevant land remediation if the materials are employed directly in that relevant land remediation. And then paragraph 7 is an expansion of the condition of whether you would have incurred the expenditure but for the contamination. And 7.1 begins with some important words, without prejudice to the generality of paragraph 2.5. This paragraph has effect for the purpose of determining whether expenditure would or would not have been incurred had not all or part of the land been in a contaminated state. So just pausing there, there are 3 ways to satisfy paragraph 2 sub 5. You can either satisfy it on its own terms, or you can fall within 7.2 or 7.3, the effect of each of those being to deem you to satisfy para 2 sub 5. So just to continue with 7, the deeming rules. 7.2, if expenditure on land is increased by reason only that the land is in a contaminated state, the amount by which such expenditure is increased shall be considered to be qualifying expenditure. And then 3, if any works are done, operations are carried out, or steps are taken, mainly for the purpose described in paragraph 4.3, so that's mitigating, minimising, etc., then that also shall be taken to satisfy the condition in paragraph 2.5. So the first deeming rule in 7.2 in effect asks, have you incurred more than you might have done? And the second deeming rule in 7.3, have you incurred expenditure mainly for a qualifying purpose? In either instance, you satisfy paragraph 2.5. But to reiterate, you can satisfy paragraph 2.5 on its own terms, and that's made clear by the introductory words of sub 1 in 7 without prejudice to the generality of 2.5. And then paragraph 8 tells us what's meant by subsidised expenditure. Not concerned with that here, it's agreed none of this expenditure is subsidised. Paragraph 9 tells us what's meant by subcontracted land remediation, and again we're not concerned with that here. And then paragraph 10 deals with the amount of relief that you can get if you subcontract to a connected person. And in effect, you can't get more relief. You can't get relief on a higher sum than your related subcontractor brings in to charge the tax. So if you incur 100, you can get relief on 100 as long as the subcontractor brings in 100 as a receipt. Yeah. We're not concerned with that. So the effect of all of that read together and identifying what I need to satisfy you about, the first tier decided that we met conditions 1 and 2. We had acquired UK land, and it was for the purposes of the trade. The first tier said we met the third condition of QLRE. This was common ground, that we'd spent money on employee costs or on materials. And we also met the fifth condition of QLRE. This was not subsidised. Again, that was common ground. And we also met condition 5, that this was corporation tax deductible. And again, that was common ground. The first tier also decided that we met condition 3, land was in a contaminated state. That wasn't addressed in the Upper Tribunal. They decided they didn't need to address that. That's their paragraph 52. And it is in issue because of my learned friend's respondent's notice. First Tier Tribunal also decided that we didn't meet the first, second, and fourth subconditions of QLRE. As to those, the second and fourth are not addressed in the Upper Tribunal, because they decided they didn't need to address it. But the Upper Tribunal did address the first condition, paragraph 4 QLRE, and concluded that we didn't satisfy it. And that's the Upper Tribunal's paragraphs 44 to 51. And each of the first tier and the upper tier decided the sixth condition against my clients. That's paragraph 12.4. And so, again, just by way of overview, our appeal relates to condition 6 and parts of condition 4, and my learned friend's respondent's notice relates to condition 3. Now, I'm sure the court has the relevant principles of statutory construction well in mind. Just for your note, there's a helpful summary of the current position in a decision of the Supreme Court in 2022. It's R on the application of O. It's in the authorities bundle at tab 9.
Yeah.
And in particular, it's paragraphs 28 through to 31. Equally, from a Lord Justice Lewison may have in mind, there's a series of principles of statutory construction that are not actually addressed in R on the application of O because the point didn't arise, about the need to read the statutory provision as a whole so as to make sense of it. And that's reflected in my Lord's judgment in a case called Pollen Estate, which again is in the fifth tab of the authorities. And if I just give you the paragraph references, it's 24 through to 26. And then on the application of those principles in that case, it was paragraphs 48 through to 49. Now we can turn them up if need be, but I'm not sure there'll be any debate between the parties as to what the relevant principles are. So coming back to the sixth condition, this is paragraph 12.4. That is clearly designed to ensure that even if you otherwise qualify for relief, no relief shall be available if the claimant or a connected person is responsible for doing something or omitting to do something at any time, as a result of which the land is in a contaminated state. Now, the relevant features that bear on that question, the court will have in mind, but NGN was briefly related to NGT Transco, so they were connected at a point in time. Each of NGN and NG Transco were, in their respective periods of time, responsible for gas distribution through the national and regional network of pipes, some of those pipes being iron pipes. So NGN itself has thousands and thousands of kilometres of pipes. I'm told enough to get us to Sydney and back again if you lay them out in a straightish line. Neither NGN nor NG Transco installed those iron pipes. They were last installed, so far as we can see, in the early 1970s. And if it becomes material, there's a rather useful history of the gas distribution network in an earlier Special Commissioner's case involving Transco. It's called Transco and Dial. It's in the bundle at tab 4, and that from paragraphs 15 through to 51 sets out the history of the UK's gas network and the different sorts of pipes that are used in different parts of the network. But relevantly, neither NGN or NG Transco installed the pipes. Each of NGN and NGT before it still has a regulatory obligation to keep the gas flowing through the network. Each of NGN and NGT Transco had and have an obligation to replace or to line the iron pipes with HDPE pipes over a 30-year period under the 30-30 programme. Now, given the scale of the problem, that cannot be done in a day, nor can the network be turned off for upwards to 30 years whilst the work is done. So when we come to test the practical application of Condition 6, we say that Condition 6 must be made to work in a commercially realistic, sensible manner in the real world. And equally, for the purposes of Condition 6, in my submission, one has to assume that NGN is otherwise entitled to the relief. If I'm not, if I failed some other condition, we never get here. So if we're going to test Condition 6, we ought to proceed on the basis that I've satisfied Conditions 3 and 4. So the barrier in 12.4 applies if NGN or NG Transco is wholly or partly to blame for the land being in a contaminated state.
And what time for the land being in a contaminated state? At the time of acquisition, if you're reading this as a whole, or at any time?
Certain elements of the test look to the position at the time you acquire the land. 12.4 deliberately, apparently, says at any time.
Well, it does, but after it's talked about the land, all or part of which is in a contaminated state, which suggests it's picking up the condition which the FTT referred to as 3.
Well, yes, I see the force of that. The case against us is that reference to at any time is deliberate. And what it's asking is the land in a contaminated state because of something you have done or not done at any time? Now, even if one reads it at any time since you acquired the land, that I think is not going to help me on the way my learned friend sees the legislation.
But if you read it as land that you had done at any time before you acquired it, then it would make a bit more sense.
Well, if you'd contaminated it before you'd acquired it.
Yes, absolutely. Or as in this case, it said that your related company had contaminated it.
That would make sense, and it would make.
And then you reading the whole of these provisions as a coherent whole. Otherwise, no one can ever qualify.
Well,
Depends on what you mean by how else you interpret the rest of the condition.
Well, that's where the rub lies. Either one has to worry away at the meaning of at any time, or one has to worry away at the meaning of as a result of.
Well, you've also got expenditure on land, part of it which is in a contaminated state, not which was at the date of acquisition in a contaminated state.
Yes, and that suggests that the relevant question is, at the time you acquire, at the time you make the claim, is the land in a contaminated state? If no, then you don't satisfy the earlier conditions. If it is, then the question is, and I'll paraphrase just for now, are you responsible for that?
Yeah. I mean, take a completely different example. You acquire what had been a petrol filling station, and there have been spills of petrol not uncommon. What you want to do with it is to, I don't know, build houses on it. But before you can do that, you've got to do some earth moving works. Well, you're not responsible. You didn't spill the petrol. It was there when you bought the land. You've done nothing. You've removed the petrol contaminated soil, and therefore 12.4 doesn't bar you from claiming relief.
And well, if we just take your logic to that, let's imagine that you buy the land on the 1st of January. You spend 6 months thinking about the problem, then you start the exercise to cure, and it takes you 6 months or another 9 months to cure it. Now, there is a period in which the land is in a contaminated state after your acquisition, where it could be said against you, well, you have omitted to cure it, and therefore 12.4 is a barrier. The logical effect of that is almost nobody will qualify for relief, because it doesn't reflect the fact that there is always going to be a period of time after acquisition before you can cure. So 12.4 has to be read somehow so as to reflect the fact that there may well be a perfectly reasonable period between acquisition and cure. 12.4...
Unless you read it is in a contaminated state, which, as my lord points out, is present tense. But that must refer to the time at which you took it, because this is all about getting contaminated land and then spending money on getting it right.
Well, the incentive is to encourage people to take on, call it brownfield sites, and turn them back into, quotes, good land again for development or agriculture.
But that only works and avoids the argument about omissions if you read land, the contaminated land, as the land that you've acquired in condition 3.
Well, I think if you then style the 12.4 question as, was the land in a contaminated state at the point you acquired it, or a related company acquired it, because of something you did?
No, it's you acquired it. It's when you acquired it, had you or a related company caused that contamination?
That would deal with the difficulty of the delayed cure.
Yeah.
And there's another reason 12.4 has to be read so as to give effect to the whole, because we saw from para 4 that you get relief if you mitigate or minimise. So it's not only available if it's a perfect cure. So if you've only minimised, and you read 12.4 apparently literally, because you failed to perform a perfect cure, you've omitted to do something that would bar you from the relief. And that can't be right. That's not what 12.4 was designed.
Another factor question is whether or not what you are doing, carrying on doing, i.e. pumping gas through the pipes, is contributing to the contaminated state.
Well,
because that also, the interpretation of that is also relevant in deciding what at any time means.
Well, and here to descend towards the detail of our case, neither we nor NGT installed the iron. But both of us have continued to pump the gas.
But the iron doesn't cause the harm. It's the combination of the iron and the gas that causes the harm.
My lord. Yep.
Partly.
Well,
therefore you're bought by part.
And now we get to the basis on which I lost in the Upper Tribunal, which, and your lordship sees this, but the Upper Tribunal said, well, here it's, the iron is not a problem on its own. Pumping gas through plastic pipes is not a problem. It's pumping gas through iron pipes that is the problem. That's the possibility of harm. The Upper Tribunal said, well, you're partly responsible for that because you've continued to pump the gas. And
on that interpretation, could anybody in your client's position ever qualify for the relief?
No.
But if you read condition 6 as referring to the land at the time of the acquisition, it may not help you in this case because of your relationship to NGT and what they had done. But then 12.6 doesn't become this artificial barrier where you take a bit of time to look at the site and work out what you need to do. And it also means that you're looking at what anyone has done to create the contaminated state which you have acquired and which, on this theory, you're going to put right.
Well, it would, if we strip out for a moment the related party who held it before us, so just keep it simple, it's just that we buy the land, your lordship's way of reading it would deal with the delayed cure. Because you would ask, are you responsible at the time you acquire it for the contamination?
The contamination and what you're repairing is that bit which was contaminated at the time you got it.
And that's I'm assuming, for the purpose of that example, that I have not. Again, I'll paraphrase what we need to turn to this, but I have not made the pollution worse.
Yeah.
It's I don't know. It's quite an artificial set of facts. Let us suppose that you sold the land to a developer. A gas transporter sold the land to a developer. And the developer doesn't pump gas through it. He just acquires the land with some iron pipes in it. And on that basis, it's not contaminated at the date of the acquisition. It's only contaminated because of the continued flow of gas.
On this fact pattern, yes, if the pipes were corroding in some way that itself caused harm to the soil, then that would be different. But
through rust, you mean?
Yeah.
I mean, that's...
Go back to the time. Are we still responding to my lord?
Well, I take my lord's point, and my Lord Justice Dingemans' point, but the reading of 12.4 has to cater for both the delayed fix
No, I understand.
and the partial fix.
Yeah, I understand that.
And the case against my clients is you continued to pump the gas,
Yeah.
as did your related company. So the fact there's a related company here doesn't really turn the dial, because we've done the same thing. Neither of us put the iron pipes in, both of us have pumped the gas.
Yes, indeed.
It's a little bit of a red
Yeah,
herring.
but that's what differentiates this case from a sort of plain vanilla, I buy an old petrol filling station and the ground's full of petrol. It's there, physically, in the ground, and I've got to do something about it.
Yeah.
Can I, picking up on my Lord Justice Dingemans' point about at time of acquisition, in your skeleton at paragraph 12, your I think it's your replacement skeleton. I hope it is. It's one at 12 in the bundle. The bundle is expertly prepared, so I'm sure it is. Yes. 12.6, which is where we are, isn't it? Subparagraph 6 of your paragraph 12, you say the land must not have been in a contaminated state. Where does the must not have been come? And because, as just put there in that bold way, that might be consistent with at the time of acquisition.
I think, well, it's just a consequence of the way those subparagraphs are set out in the past tense, i.e. a reflection of what the tribunals below had decided. So your lordship's point is right with respect. The statutory language is it in a contaminated state?
Well, it comes from paragraph 3, subparagraph 6 of the Upper Tribunal decision. In fact, you've just lifted it from there.
Yeah.
And they have paraphrased it. But that may be because to make sense of this as a coherent whole, it has to mean that, or it may not.
If the passing of the gas through the pipes automatically is contamination.
Well, the way that the First Tier and the Upper Tribunal in effect decided against us was not to take the point that we'd omitted to act over the 30-year period, and that might be said to be a contaminating omission. Well, if it were relevant, I would say that you can't read 12.4 in that way. But what's said against us is that we've committed a contaminating act.
Well,
Yeah.
the only possible omission would be you didn't turn off the gas supply. You omitted to turn off the gas supply. I mean, you can say, well, you continue to pump it, well, that's an act. Or you omitted to turn it off, that's an omission.
Or we failed on day one of acquisition to cure the problem nationwide. But that's just not really.
Is the problem here we're trying to fit a square peg in a round hole, and this provision was not intended to cover this actual situation at all?
Well, my lord,
It's been designed for petrol stations, like
well,
my
it
lord's-
undoubtedly applies to petrol stations. But in the petrol station example, you would expect the would-be developers to have a kind of freehold or a leasehold interest.
Certainly.
Whereas between 2001 and 2009, this relief worked for people who had lesser interests in or rights over land.
Well, I mean, that's another oddity, and different. It's another very unusual fact situation, because you've got that you didn't acquire an estate in land, you acquired an interest in land. That the land wasn't contaminated absent a flow of gas, that your predecessor pumped the gas, and so did you.
As had their predecessors before.
And no doubt back to the 18, whatever it was.
Yeah. I mean, very broadly, it was local town companies up to nationalisation in 1949, nationalised between 1949 and 1986. Transco is, in effect, the national gas transmission company from 86 onwards, and then the regions are spun out in 2005. But once you get beyond the local town gas networks of the 1880s, these pipes were put in around the country, and they have always been used to pump gas.
Yeah.
Like 100 years, maybe more than 100 years. But one can't proceed on the basis that this legislation was only aimed at the developer who acquired an estate in land, because it wasn't between 2001 and 2009. So one has to make it work for people who might have a lesser interest, of which utility companies of various sorts are perfectly good examples. So we have to make 12.4 work as part of a coherent whole in a world where a deferred cure shouldn't be a problem, and a partial cure shouldn't be a problem, but isn't a problem, because we know it's not. And what is said against us here is not you put the pipes in, but you continued, brackets, as you were obliged by a regulatory regime to do, to pump the gas, and it is here the possibility of harm, and the possibility of harm only arises from the presence of the gas inside the iron pipes. So the basis on which the Upper Tribunal decided against us was to say, if you look at 12.4, you have continued to pump the gas. They don't put it this way, but they could equally have said, or you've omitted to turn the gas off. And therefore you are partly responsible. But they have to mean by that you're partly responsible for the land being in a contaminated state.
But as we agreed, I think if that's right, nobody in your position could ever get the relief.
Correct. Now, our answer to that is to say that 12.4 clearly has to be read so as to make, or so as to allow the rest of the schedule to work effectively, even in the case of utility companies. And the fact that we continued to pump the gas still does not allow the conclusion that we were partly responsible for the land being in the contaminated state, because we had no responsibility at all for the installation of the iron pipes.
But you've already accepted the iron pipes on their own are not enough.
Well, the iron pipes, the first tier, there was a debate in the first tier as to whether the iron pipes were a substance. And my learned friend wants to pursue that point on condition 3. But it was and is the case that the iron pipes on their own do not give rise to a possibility of harm.
Yeah, I think that's all in paragraph 12 of the FTT, isn't it?
And equally, just to reiterate, having gas in HDPE pipes
It's also not a problem.
is also not a problem.
It's the combination of the two.
Correct. So we say that one has to recognise that it's the combination that is the contamination, and then ask, do we have any responsibility for that combined state of affairs? And we say no.
Combination of the pipe.
And the gas.
Why are you responsible for the gas if you're still pumping it?
Well, look, this is conceptually perhaps difficult, but vitally important for my submission on condition 6, that the contaminated state is the combination.
I see. So without gas by itself, not contaminating. So it's only because of the iron that the iron pipes that is the contamination.
Yeah, and you have to ask. The way perhaps to test it is to imagine two companies. Company A installs some iron pipes and pumps gas. Company B adds to that network by installing some more pipes and pumps gas. Then you would say of a given plot of land, each of them is partly responsible for the contamination because they've each added iron and gas. But where you have an unrelated party...
Oh, I don't understand that. You've got company A puts a pipe under Blackacre and company B joins to that pipe under Whiteacre.
And I'm assuming it's the same plot of land.
Same plot of land. But
What, with two separate pipes going through the same plot?
Yeah. Not impossible. This applies, we also, I mean, not my client's interest, but also one needs to think about oil pipelines, other sorts of pipelines. So if you have a given plot of land where there are two companies, each of which have put in iron pipes and pump gas or oil or whatever it may be, statute would work to say each of you is partly responsible for that combined state of affairs. But we're not that fact pattern. We are a case in which somebody unrelated to us put in the iron, we and our related company have pumped the gas, but one has to read 12.4 and that reference to wholly or partly as recognising the example I've just given to the court, but not barring you where you are not at all responsible for the combined state of affairs. And
The only other solution that works is to read it all as at the time of acquisition, when you had gas and pipe work at the same time when you acquired it. And that's the contamination that 3030 requires you to put right, fine, when you get round to it. Because that then meets the point about omissions, etc., while continuing.
well, it would deal with the delayed cure, because you don't pay attention to what happens afterwards, and it would also deal with a partial cure, because you don't pay attention to what happens afterwards. But then the only relevant question is, were you responsible for that state of affairs at the time you acquired the land?
Well, not at the time you acquired the land. When you, the minute before you got it, it had an iron pipe and gas in it. And if that is a contaminated state that you've got to put right, then the system works as a coherent whole. But without that, you're having to pretend that the pipe isn't yours or something else like that.
Well, I think this fact pattern is complicated by the fact that there was for a period of months a related company. But if we just test your lordship's thesis, you would then ask, at the time you acquired the land, is the land in a contaminated state? Yes, because it's got iron pipes and gas. But are you, as the acquirer, partly or wholly responsible for that state of affairs? We would say no.
Can I just go back to my hypothetical filling station? Filling station is sold by one oil company to another. And at the date of the acquisition, petrol has leaked into the ground so that it is contaminated. The new oil company continues to sell petrol from the site, and more petrol leaks into the soil. Is that to be completely disregarded for the purposes of 12.4?
That would be an example where part of the contamination is the fault of oil company 2.
So we're looking at the contamination at a date after the date of acquisition. In that example.
In that example, yes.
Now, is that because we're told by 12.4 that the question is the question relates to land, all or part of which is in a contaminated state?
And then one has to read on wholly or partly, now as a result of, so there's a causation link there.
Yes, indeed.
Of something that you have done or not done at any time.
Yes. So what you have done or not done after acquisition is relevant to the correct interpretation of 12.4.
Unless one takes my Lord's approach, which is to say that 12.4 was only really designed to...
Yes, well, that's what I'm...
And that in my Lord's example, they don't get the extra cost of tidying up their own contamination because they caused that, and you're looking back to the contamination that you have inherited. And that's the whole point of the statutory scheme, to get people to get estates in land where they're going to buy and tidy up the land.
Yeah, and to take my Lord's example, if oil company 2 ends up spending 120 and 20 is attributable to the harm it had caused, no relief.
Because the 100,000 related to the state at which it acquired it. And then land has the same meaning throughout, because you can't change the meaning of land partway through a statutory code.
Well, the Lord, as a broad principle, that ought to be true. But the difficulty the tribunals face below is that it's...
Your
really
case, in your case, as a result of, is perhaps the key phrase, is it?
Yes.
Because the land is, the contaminated state of the land is gas going through an iron pipe. But that's as a result of the iron pipe being installed, and that's the thing which was done before your company or its connected company.
Long before we existed.
Had you installed the pipe, it would be different. So it's the thing done as a result of anything done. Is the thing done is the installation of the pipe. The contaminated state is gas going through the pipe, but the thing done is the installation of the pipe.
Yes.
So the gas going through it, although it contributes to the contamination, it's not the thing done as a result of which it's occurred.
Lord,
that's your case.
Yes, even if we read at any time in the way that my Lord may not.
That gets round my Lord's anxieties, anxious scrutiny of this.
It may well do. But even putting that point aside, there is a causation test here.
Yeah.
And I put it rather gently, but to make this work in a world where it was clearly designed for a period of years to extend to utility companies, you have to worry away at either at any time or as a result of.
Well, if I'm right on, if what I've said about your case is right, what does at any time add then to that? I mean,
well, on that fact pattern, it wouldn't add anything, because you either stand or fall by the causation, and if you satisfy that causation test such that there's no barrier, then reading at any time doesn't matter, however you read it.
In fact, it might support your what I've said is your interpretation, because it would clarify that it's not just before acquisition.
Yes, it becomes easier to read at any time as meaning what it apparently means, which is any time.
Yeah.
But the difficulty that both the first tier and the upper tier faced here on this condition 6 was trying to make it read sensibly within the context of the code, the schedule as a whole. And each of them, although they put it slightly differently, found against my clients, but only because we continued to pump the gas.
One of them referred to the related company.
And it's compounded here slightly by the related company, but relevantly, if my client NGN are going to lose because they pump the gas, then the fact that NGT pumped the gas as well is to no additional effect. I've already lost. And there might be a fact pattern where they had pumped the gas and we hadn't. But because they're a related company, we'd still be trying to apply para 12 to their actions. But because we've both done the same thing, the fact that there's a related company here is true, but it doesn't actually turn the argument one way or the other.
But that's why this fact pattern is so unusual. I mean, if you'd acquired the land from NGT and stopped pumping gas, it wouldn't have been contaminated. So.
Perhaps if I just draw the threads together on this point, the Upper Tribunal addressed this debate in their paragraphs 38, 40 and 43 through to 44.
You want us to turn that up?
I'm not sure it's necessary.
All right, just give me the paras on.
38, 40 and 43 to 44.
Yeah, that's the FTT.
That's the Upper Tribunal.
Oh, the Upper Tribunal, sorry.
And that's where they conclude that we are partly responsible because we continue to flow the gas. And we say that's an error of law, it's a misreading of para 12.4. And to reiterate, the court has this point, but we say reading 12.4 in the way that we've identified gives sensible practical effect, recognising the real world here that we couldn't cure this problem on day one, we couldn't turn the gas off, and yet this was in part for a period designed to deal with people who had lesser interest in land and freehold and leasehold. So that's condition 6. Thus far I was proceeding on the basis that I was right about the earlier ones. So let me then just go back and deal with these. Condition 3, this is the question whether land is in a contaminated state. And just to orientate the court, it's paragraph 12.1b. And this is asking a question at the time of acquisition. Again, it's slightly oddly expressed because it asks at the time of acquisition, all or part of the land is or was in a contaminated state. It's not immediately clear why you need that reference to or was. Because if it was contaminated but it's been cured, then you wouldn't expect there to be any further relief. Whereas is makes sense, but by the by, it has to be land in a contaminated state. First Tier Tribunal said that it was, and that's their paragraphs 26 through to 48. and this point was not addressed by the Upper Tribunal. They said they didn't need to. So the first tier's reasoning was this. There is a possibility of harm from the explosion of the gas. That's the first tier, para 41. That possibility of harm arose from the pumping of gas inside the iron pipes. That's paragraph 41 again. Gas is a substance for the purposes of para 31 of the schedule. That's the first tier's paragraph 42. Iron may also be a substance for the purposes of the schedule. That's the first tier at paragraphs 43 to 45. But in any event, the land is in a contaminated state, and that's their paragraphs 46 to 48. Now, the case against me on condition 3, under my learned friend's respondent's notice, he says, well, the iron in itself is a substance. You accept that iron is a substance. But he says iron in pipe form is not. And that's my learned friend's skeleton at paragraphs 40 and 51 to 53. We say, not so. Iron in pipe form is still a substance. Substance is defined as natural or man-made. And the fact that it's in pipe form makes no difference. It would still be a substance if it was in sheet form, or tubular form, or ingot form. Doesn't matter. And my learned friend's skeleton offers no reasoning here, other than to assert that this is not what paragraph 3 is designed to deal with. But there's no reasoning is offered as to why that conclusion ought to be right. So the first proposition is iron in pipe form is not a substance. Second proposition is, from a learned friend on the respondent's notice, is to say that gas is not in or under the land because it merely passes through the pipes that are under the land. And that's his skeleton at paragraphs 40 and 54 to 56. And the way he rationalises that is to say that this regime is only concerned with a substance that is permanently under the land, or perhaps if it's static, so that something intentionally transported is not covered. And our headline answer to both of those contentions is that my learned friend is rewriting the legislation. There is no requirement as to whether a substance is static or moving.
Well, in fact, the schedule refers to controlled waters, and if you're dumping stuff into controlled waters, it's unlikely to stay still.
It will move. It doesn't refer to something permanently under the land, not least in part because it refers to gas, and gas can escape. And we know it extends to gas, and unless you corral gas in some way, it will dissipate into the atmosphere. So the proposition that gas inside some kind of container is not intended here would make a mockery of the reference to gas being a substance for the purposes of this schedule.
And the Upper Tribunal, in dealing with condition 4, I think, gave the example of landmines.
Yes.
Which one might think was highly desirable to remove, but on HMRC's case, they wouldn't be a substance.
Well, we had exactly that debate, or tanks buried high nuclear waste, or something of that ilk. And nuclear is perhaps a bad example because nuclear is carved out of this regime, but think of some other toxic substance, typically buried inside a container. The fact that it's inside a container under the earth is not a concern of the statute. You're positively encouraged to remedy the land by removing that sort of thing. And there's nothing in the definition of substance or elsewhere in the code that would allow you to conclude that either the iron in pipe form doesn't count, or that the presence of gas inside some kind of container also counts.
If one goes to my lord's petrol filling station, the hydrocarbons all go on the aquifers and continue to go leach from the contaminated ground.
Yes, and some of them might be in a tank that leaks, some of them might be in a pipe that leaks, some of them might be out in the soil. But the purpose of the statute is clearly designed to encourage you to remedy all of those. So I'll say no more about condition 3, but we just think, well, everyone's trying to rewrite the statute there so as to raise an additional barrier in our way. Condition 4 is a little more complex, and the court will recall that condition 4 is whether my clients incurred QLRE, qualifying land remediation expenditure. And that means satisfying the 5 sub-conditions. And it was common ground that the 3rd and the 5th conditions, sub-conditions...
I've got to remind myself what they are.
It's paragraph 4... Sorry, paragraph 2...
Yeah.
And below, we satisfied the 3rd condition.
Directly undertaken by the company, yeah.
So the 3rd condition is on employee costs or on materials.
Oh, I see, yes.
And we satisfied the 5th condition that this was not subsidised.
Was that common ground?
Yes.
Yeah.
Yeah, this was...
Yes.
We were spending our money, not somebody else's. But what the first tier said, and this is their paragraphs 58 through to 62, they said, well, you didn't spend money on the land in the first condition, which is para 2.2, and you didn't spend money on relevant land remediation, second condition in para 2.3, and you didn't spend money on the land in the 4th condition in para 2.5. Yeah, there was an immediate...
Sorry. 4.5 talks about expenditure wouldn't have been incurred had the land not been contaminated.
And
whereas on the land comes into condition 1, doesn't it?
And the first tier said, if one looks on at 7, 7.2, the first tier said that's got a reference to expenditure on the land.
Oh, paragraph 17.
In the first tier decision.
Paragraph 7.2 of the statute.
Oh, sorry.
Yeah.
So the first tier said 7.2 refers to expenditure on the land. Now, there was a problem with that conclusion, which was common ground in the Upper Tribunal, that you could satisfy that condition either by the words of 2.5 itself or by 7.3, neither of which required expenditure on the land. And the Upper Tribunal put that right in their paragraph 56. They had the section at the end where they were correcting errors of law that we had relied upon but didn't get me home.
But the first condition in paragraph 2.2 is that it is expenditure on land. That is a condition you do have to satisfy.
It is. Now,
and paragraph 7 doesn't really bear on that. Either you satisfy it or you don't.
well, paragraph 7 only bears on the 4th condition. So it was said against us we've failed the 4th condition. That's a bad conclusion and put right in the Upper Tribunal.
But it's the same point as saying you failed on condition 1, isn't it?
Well, it's condition 1 and 2, because in order to be relevant land remediation, you have to meet paragraph 4, and that was 4.1. It has to be expenditure in relation to land. So what was said against us is you spent money on materials and employees. So there's digging, putting pipes in, recovering. So you satisfy the third condition in 2.4, but you haven't spent money on or in relation to the land so as to satisfy the other subconditions. And the Upper Tribunal accepted the broad thrust of that case on the basis that in the Upper Tribunal's words, the real world focus or the object and purpose of the expenditure was the pipes, and thus you hadn't spent money on or in relation to the land.
And that raises again the question of whether the pipes are part of the land.
Well, it raises logically one prior question is does land here mean the earth or a legal interest? And then the next question is my Lord's observation as to does one sidestep the first question if the pipes are part of the land? But can I just continue with the explanation of the case against me? In effect, well, my Lord friend had an argument before the first tier, which he reiterated in writing before the upper tier, that this was expenditure on chattels, being the pipes, and therefore it couldn't be on the land. And the Upper Tribunal don't accept that, but they accepted a closely related argument my learned friend advanced in oral submission, to say, in effect, the real focus here is the pipes, and thereby you can't satisfy the requirement that it be on land or in relation to land. Now, for our part, we say that's to misread the series of carefully crafted subconditions in paragraph 2. So for our part, paragraph 2 asks a hierarchy of questions. Question 1 is, are you spending money in relation to land that is contaminated? Because
Well, you've changed on to in relation to.
my Lord, I have. And we're going to see why in a second.
Yeah.
But the first question is, if you're not spending money on land that's contaminated, you need go no further. So, are you spending money on, and I say, in relation to land that's contaminated? Second question, is this expenditure on relevant land remediation? And that asks, have you spent money in relation to land? Then the third question is, well, what are you actually paying for? What do you get for the money you spend? You only get relief if you spend money on employees or materials. Then the fourth question asks, have you incurred money that you otherwise would not have spent? So if we're going to give you the incentive of an additional relief, it has to be for money that you otherwise would not have spent. And the last question is, are you subsidised by somebody else? But if you read that reference to on in the first condition and the reference to in relation to in the second condition, in a way that requires you to spend money on or in relation to the land, you then have to give some meaning to the third condition, which requires you to spend money on employees or on materials. The draftsman uses on in the third condition and in the first. And the second condition is in relation to. So for our part, we say to to read those conditions as a whole so that they make sense.
So the first condition, so to speak, brings in paragraph 4 and its reference to in relation to. And you say that
the second condition does that, my lord. Because that's relevant land remediation.
Yeah, yes, indeed. But you carry that back into the first condition, so that they are read consistently.
Yes. And that.
And just as an aside, it doesn't help on this case. What happens if you hire plant? Is that expenditure on materials or employees? And suppose you hire a digger to dig out contaminated soil. Does that count?
If you subcontracted that, it could count. If you've not subcontracted it.
No, I've got one of my chaps. I've hired a digger and I got one of my chaps to drive it and operate it. Doesn't sound as though it counts.
I'm not sure it counts, no. Can I think a little more about that, but by instinct, no, because it's not a...
It's not materials in the sense that it's going into the land.
It's not an emolument, national insurance or pension, and it's not on a material. The pipe here is the material.
No, I follow. I mean, it's just that, you make a lot of carefully crafted conditions.
It's not qualifying expenditure on subcontracted land remediation. See paras 9 to 11 then.
Well, it could be if you subcontract out the exercise and you pay your subcontractor.
Yeah.
But if, in my lord's example, it's
you just hire in a piece of plant.
Yeah.
So on it, is any works if on in the subparagraph 3 means in relation to? In the first condition. In the first condition, expenditure on land.
The first condition, yes.
In relation to
it works, but only works if you read that as in relation to.
Yeah.
Because you're asking a different question. You're asking, is this the contaminated land you're spending money on? If no, no further. If yes, go on. You then ask, is it in relation to land where you're getting relevant land remediation, so RLR? If no, stop. If yes, go on. You're then asking, what are you actually spending the money on?
Yeah.
And just in answer to my lord's question, I'll take instructions, but of course, para 6 uses the terms materials, but they have to be employed directly in the relevant land remediation. So the digger would be employed directly in the relevant land remediation. There may then be an open debate as to whether the digger is a material. And it's more naturally described as a tool or a machine, but can I come back to that if it's material? But we say for our part, one has to ask a series of interrelated but hierarchical questions that give proper effect to para 3 sub 4, where on clearly does mean on, what have you spent the money on? But the earlier references to on must be read as in relation to. That's how the subparagraph, the paragraph as a whole works. And once you do that, then we satisfy the first and second conditions. It ought now to be common ground that we satisfy the fourth condition, because that has no on or in relation to. You can meet that fourth condition by having the right purpose, and we did. And the way that the Upper Tribunal decided it against us was to say, well, the object and focus of the expenditure has to be land. That's a direct quote. Or there has to be a sufficient real-world connection with the land. Another quote. And we say that is to rewrite the statute and to impose statutory conditions that are just not there. And they are, with respect to the Upper Tribunal, hopelessly vague in their ambit. Now here we make, I think, 5 or 6 interrelated criticisms of that conclusion. And can I just invite you to turn up our skeleton argument at paragraph 40. Tail end of paragraph 39. We're here criticising the object and focus and real-world connection reasoning of the Upper Tribunal. We say this is an error of law for 6 interrelated reasons. This is Core Bundle, tab 2, page 27. I'm sure the court has this in mind, but rather than me read it out, can I just invite you to run an eye down our 6 reasons, those paragraphs 40 through to 45.
So really the key point from your interpretation is that don't focus on the word land, but focus on land in a contaminated state.
Correct. That's the relevant phrase that's being tested in that first condition.
As defined in para 3.
Yep. One last aspect of this condition 4. Before the First Tier Tribunal, there was evidence from Mr. Wood of NGN as to what the money was spent on. And what he did in his first statement was to identify the money they spent on the 3030 programme separated from the money they spent on other things. But that first statement didn't break down into more granular detail what they spent the money under the 3030 programme on. And once this point became material, we applied in the Upper Tribunal to put in a second statement from Mr. Wood, where he said, well, if I extrapolate the tables I put in my first statement and I go down to the next level of detail, you'll be able to see what we actually spent the money on. And I'll paraphrase sheet slightly. Once you do that exercise, about 95% of the money is spent on the digging and the recovering, and about 5% is on the materials. So we applied in the Upper Tribunal to put that in. Well, no friends objected on land and martial grounds. We were going to have that debate in the Upper Tribunal, but it didn't become material. So we appealed against their refusal to admit the evidence.
Was there a refusal? An actual refusal? Or they just found it not necessary to deal with the application?
They just found it not necessary to do so.
I mean, I'm probably speaking off the top of my head, but if you were to succeed on this appeal and succeed on this ground, I would be inclined to remit it to the Upper Tribunal, who are better equipped to find facts than we are.
Lord, and perhaps this is not quite an answer to that observation, but to avoid any procedural bear trap, we've also applied to this court
Yes, I know.
to adduce, in case it was said that it wasn't sufficient that we'd appealed against the Upper Tribunal's decision not to adduce it, or at least failure to.
I wasn't aware they had actually refused.
I'm not sure they did. They just found it not necessary.
Necessary to decide, yeah.
Yeah.
So if it were to be remitted, I suppose that's still a live application before them, because they haven't dealt with it.
And if your lordships tell them that that's material, then that would be a perfectly good tribunal to resolve that issue. Now, as it turns out, my own friends, clients of mine had some correspondence before the Upper Tribunal as to what was the significance of the evidence. The evidence itself is, I suspect, not in doubt. They spent the money on what they spent the money on. It's just a table of figures. But I'm not sure at this stage of the argument you need look at that when we need address it. because it only may arise if you have to answer a question that asks relevantly for these conditions, does it matter whether they spent money on pipes or digging? For the reasons I've already given to the court, we say you just don't get that. You can ask a perfectly sensible hierarchy of questions, each of which we can satisfy without actually getting into Mr. Wood's second statement.
Yeah.
So the errors of law that we identify on condition 4 are set out in those paragraphs in my skeleton. And subject, my Lord, to perhaps coming back in reply once I've reflected a little further on 12.4 and the reference at any time, and also your Lordship's observation about whether the pipes are land. I can reflect on both of those and come back to that in reply.
I mean, I mentioned the case of Simmons and Midford, which Mr. Justin Buckley, I think. And one of the things he said in that case was that, I think it was a drainage case rather than a gas case, but to do with buried pipes. The purpose of the pipe was to protect the dominant owner against liability to the servient owner from water, whatever it was that was going through the pipes, escaping into the land. So the purpose of the pipe is to insulate the dominant owner, by analogy NGN, against liability to the landowner through whose land the pipe passes, whether it's private or highway or whatever.
And we haven't addressed it, it's not material now, but you'll perhaps recall from the first tier that the first tier analysed the land interest question by looking at public land and private land and some land by virtue of which we only have statutory rights and contractual rights.
I mean, I gather from the skeleton arguments in the first tier tribunal that land or not land is to be decided according to the common law. There were no specific provisions in the gas legislation which deal with it. I mean, I know that there are specific provisions in the water legislation about vesting of pipes in undertakers, and there are some provisions in the gas legislation about fittings in buildings not becoming fixtures, but I haven't tracked down any particular legislative provision about distribution pipes. And I didn't think that any were relied on in the FTT.
That's also my belief, my Lord, and I'll check and take instructions over the short adjournment. But unless I can help you further, those are my submissions on the 3 conditions.
Thank you very much, Mr. Beale. Yes, Mr. Yates.
Thank you, my Lord. Whilst we're on that topic, if I may just clarify what was said on the question of chattels and land. Below.
Yes.
And if you could take up this supplemental bundle.
Supplemental, yep.
Yep. And if you could turn to tab 4, you can see the revenue skeleton argument. And if you turn up page 7 of the skeleton bundle, page 48.
Yeah.
The case the revenue was relying on was Woolstanton. And you can see the extracts set out there. They're not in the bundle now, obviously, because the status as chattels was conceded. And that goes on then to paragraph 29, where the High Court, the Australian High Court, then addressed the same question by reference to analogous gas legislation as well. So that was the basis upon which, unusually, perhaps, the pipes were to be seen as chattels. Not, and it's been some time since I've browsed the Gas Act, but I believe you're right. The fixtures in the house, for example, are found not to be a fixture.
That's because the statute says so.
Correct. And as I understand, it's been some time since I've browsed the Australian High Court decision as well. But I think it's by necessary implication simply because the Gas Act gives you so many powers to do X, Y, and Z, that there's an implication that it doesn't become part of it.
Yeah, I mean, I'm not sure that Stanton, which we looked at in the Vauxhall case, really says what you say it says, but...
Well, the first instance judge does say it's chattels. It's not common.
It says it's common ground. Oh, sorry, in More Stanton, Mr. Justice Evershed.
Yes. Yeah. It comes up in the oral argument you can see in the report, and then frustratingly the Court of Appeal then doesn't really address it. But the ball is, as it were, picked up by the Australian High Court, who do ask the question, is it land? In the context of analogous but not obviously the same gas legislation.
Well,
so that was the
I follow
state of the law such as it
but
was.
Then you've got cases like BMI and Mellowish.
Certainly 3 years ago I poured through this with a huge amount of anxious scrutiny, but I can't confess I have it at the front of my mind.
You ought to realise you've ended up in front of Lord Justice Lewison and have it at his fingertips.
It's not an arena I choose normally to go into, I'm prepared, no, in the question of land. But that was the point as is. And then if you go to the transcript, tab 5, and it's page 7 of the transcript, page 60 of the bundle. The questions raised before cross-examination there.
Yes. Yeah. I mean, I understood that it was common ground for the FTT that these were, or these remained chattels. Can I put it that way?
Yeah. And I think, obviously, the appellant very much wants them to remain its property. I think they're listed in its balance sheet as being of quite some value. So it might give rise to a separate question as well for them commercially. So that's the dynamic as it was before the FTT. And it was certainly, that hasn't been gainsaid, as it were, in the
No, I follow.
Or now. So that's the procedural position, at least in relation to that question. So if I may, I'm just going to take the 3 points in the same way that my learned friend has, and so the starting point is back to paragraph 12.4, if that's all right.
Condition 6.
Condition 6. So if we can just take up the authorities bundle again. So if we go to page 11, that's 12.4, and obviously I've been following the debate as to at what time do you test the contaminated state. And it's undoubtedly clear that if you look at paragraph 1, sub 1, paragraph 12, obviously it's a precondition before you can even get relief that the land has to be contaminated as at the time of acquisition. That's clear. I think that's clear with Mr. Peacock, it's clear with me. What you then are asked to look at paragraph 12.4 and what the revenue say is you're asked to look at the state of contamination at the point of expenditure. And that makes sense for several reasons. The first is if we jump back to paragraph 2, sub 2, the first condition for QLRE is that it is expenditure on land, all or part of which is in a contaminated state. So that's the first point. The main condition for QLRE is addressing it at the point of expenditure. The second point, which I'd make in relation to that issue, is if one looks at 12.4 and how it might operate rationally, dealing with my Lord Justice Lewison's point, let's say you have the petrol station and you've acquired it which is contaminated with petrol, and then during the course of your ownership, prior to remediation taking place, more petrol spills in. And so if one is looking at the point of remediation, asking the question, who's responsible for the state, that would obviously make logical sense, because you're looking at both at the blame of the original owner, if they are connected with you perhaps, and also your own actions as owner, which ultimately, it's not difficult to foresee situations where the actions which you have taken as owner or omissions you've taken as owner has increased the amount of pollution, such as to increase the amount of expenditure required to cure it. And so it wouldn't really make any sense under 12.4 to simply stop the clock, which is after all what the FTT did. So you can understand it's a perfectly feasible interpretation, but it's one which I would invite you to reject, and it was common ground before the Upper Tribunal. That one is looking at the point of, one is looking at any time, so therefore one isn't just looking at the point of acquisition. It doesn't make any sense in terms of this provision if one stops the clock, because after all, the only situation one would be envisaging if one is looking at only at the point of acquisition under 12.4 is perhaps an unusual example where you as claimant, prior to becoming owner, have done something to the land. Now that's obviously a possible scenario, but a far more feasible one, I would submit, and one which accords with the natural reading of paragraph 12.4 is you have done something, could be before you've acquired it, but obviously the time of your ownership and what you've done on the land is obviously critical as well.
I understand that point in relation to additional contamination, but what about in relation to omission? For example, when you buy, my lord, a petrol station,
yes,
there will be hydrocarbons in the ground because that's what's happened. They'll have leaked from the tanks. It's not a question of anything else. And they will continue to go down the aquifers that run under the ground and cause problems. And if you're not repairing it on day one, minute one, part of the reason for the contamination of the land, if only because the hydrocarbon will have travelled a couple of feet overnight, is because of what you've omitted to do. And you would then say, well, you can't have any money. How does that work?
Well, in the case of omission, it must be a matter of fact and degree when looking at each case. You can't just say automatically mere delay equals omission in every single case. That is not the revenue's case. So take the example where you've taken 6 months to do some fact-finding before you do any work at all, and then you break ground, for example, 6 months later or even 12 months later. That's really just going to be a matter for appraisal, either by the revenue when dealing with the claim or, if necessary, by the FTT. Mr. Peacock would like to construct this binary outcome where
Yes.
If you're not with him on this, this automatically follows, and I just don't accept that.
Can you give an example of how someone in the claimant's position would qualify for relief if the interpretation is as the Upper Tribunal found it to be?
Well, it was very interesting listening to what Mr. Peacock was saying, because at some points he's saying this legislation is clearly designed to deal with utilities companies. And then he backtracked from that a bit and said it's clearly designed to deal with, and I accept this second proposition, people other than those with major interest in land, at least up until 2009. Mr. Peacock's submissions start with the proposition that this legislation has to be made to work for gas utilities companies. And one can understand why he says that. But there's nothing in the legislation which guides you to
So your answer is it doesn't work.
Not for...
You can think of a way in which it might work with if we have at time of acquisition, in the unusual event of the claimants having done work on the land before acquisition. But you can't think. Can you think of any way in which it works on the UT's interpretation?
For someone actively continuing to pump gas, no. I mean, on the revenues view, this is not a complicated case. And
so this is an example of a whole cohort of companies trying to squeeze into legislation which wasn't intended for them.
well, that is certainly the revenue's view. What I can't say to you is someone stood up in Parliament and said this is only for propositions X, Y, and Z. There's no admissible material which I can draw your attention to, which says gas companies are out, or it's only for this particular kind of brownfield development. And that's not my case.
Well, you've got a combination here of either an easement or something analogous to an easement, plus the continued flow of gas. And those are two unusual factual situations. Leave aside gas for the moment. Think about something like drainage. You've got a factory which is draining into a watercourse.
Yep.
Only got an easement, but there are pollutants coming out of the factory and getting into the soil or the aquifers or whatever. And somebody acquires a factory but continues to pollute. you would say that 12.4 bars that.
Yes, if they continue to pollute, there's no dispute in terms of the high-level authorities about how one goes about statutory interpretation. We can only get the purpose of paragraph 12.4 from the words of paragraph 12.4 in my respectful submission. And it is stark in that there's no de minimis, oh, you're only responsible for 1% or 5%, or only for a limited period of time. The legislation is stark, and one has to assume that's deliberate. That if you're responsible in whole or in part, you don't just get denied the relief for the expenditure by reference to your bit. I query how you can actually go about assessing that in many situations. The legislation just says no enhanced relief. After all, you still get a 100% trading deduction. It's just you don't get the super relief. So that clearly is the purpose of 12.4. And why? Well, this wasn't emphasised, but if one goes back to the definition of contaminated land, back to paragraph 3, it's an incredibly low threshold. And so let's focus on the words. So broadly, the legislation doesn't use pollution, it only uses the term pollution in the context of pollution of controlled waters, which is itself defined in paragraph 31. But when one comes to harm, you can see that set out at 31 as well. You've been taken to this, but I'll take you again. So it's bundle 23. So it has A and B, what one might think of as conventional definitions of pollution. But C is also an offence to the senses of human beings, which you can have contaminated land if there is the possibility of an offence to the senses of human beings. So that would count as contaminated land.
Maybe a pig farm or something like that.
Oh, who knows? Maybe a comedian telling jokes in bad taste. I mean, the legislation is very wide. And so Parliament necessarily then has to close it off at some stage. And paragraph 12.4 is really that mechanism. In our submission, our core submission is really, if one takes up what the Upper Tribunal's reasoning was, if I may just jump folders, as it were, to the core bundle, and take you to paragraph 38. It's page 71 of the bundle. It's really this one paragraph why this appeal fails. And everything else, what we've been dealing with today and everything else later following on from that paragraph, is dealing with, as it were, special pleading as to how we can make this possibly work for gas utilities. But that obviously presumes that the legislation is intended to cover that situation, in contrast to the more conventional situations, such as a petrol station, which my Lord Justice Lewison was addressing. So the legislation is quite clear. It's also clear both in terms of the, I suppose, hair trigger nature of when it's invoked. So wholly or partly, doesn't matter, and at any time. And whilst that, I'm not going to sort of recoil from the fact that that is a stark provision, but it's a stark provision based on clear words which Parliament has used. And no amount of purposive interpretation is going to get away from that.
In which case, you've just argued that the petrol station can't do that, because you say it's hair trigger provision. If you've not remediated your hydrocarbons travelling through the ground on day one, they're there on day two, and you've not
I wouldn't necessarily accept that, my Lord, because you have to, whether something is an omission, is something that it isn't just a question of mere delay in my submission.
What else is an omission if it's not delay?
Well, I would submit that an omission must mean delay plus or inaction in circumstances where there is an implied duty or an expectation that one has to act.
So if a company bought the
In this context of this section,
if a company buying the land, immediately turned off the pipes and did the work, what then?
so NGN acquires, well, that does beg a separate question of when it incurs the expenditure, is the land in a contaminated state if the gas has been turned off. But that just shows you the surrealness of having to deal with this situation in the context of this legislation. They can turn the gas off every time, they obviously have to. Not necessarily when they break ground in some instances, but certainly when they are handling the pipe. The gas has to be turned off, and then you see the variety of methods by which they address it. They either replace the pipe wholesale, leave the iron in the ground and have the HDP in, or they line it at stretches at a time by pushing HDPE piping through the pre-existing pipe. But again, I slightly jib at the having to try and make this legislation work for a gas utilities company in circumstances where there's no indication at all in the legislation that is the intention of Parliament.
Well, I only asked you whether to test your argument, whether a company which turned off the gas as soon as it acquired the company would attract relief. But your answer was you wondered whether it would because it wouldn't be contaminating the land. So it never attracts relief.
I'm absolutely clear that anyone in the position of Mr. Peacock's client is not going to get relief under this provision.
Well, we may disagree with you, in which case...
because, I mean, the whole submission advanced, and in particular, they say, well, it's not really the gas, it's the pipes. But that is just surreal in circumstances where the pipe is, in some senses, left in the ground, because obviously it's not causing any harm. It's the presence of the gas, and even there's still harm, even within the HDPE pipe. I don't accept, and it wasn't the evidence before the FTT, that once you've got the HDPE pipe in, it's absolutely safe. Of course it isn't. Obviously the risk of harm is significantly reduced. But it wasn't my own friend's case, and it wasn't even the evidence before the FTT, that there's zero risk of harm. Why? Because there's inflammable gas getting pumped through HDPE pipes, which is not invincible to the same, doesn't corrode, but it's still subject to, for example, ground movement, exactly. So it's been a fascinating sort of forensic exercise in seeing how someone can avoid the big elephant in the room, which is Mr. Peacock's clients are pumping vast amounts of inflammable gas through a pipe and saying it's not, the problem's not the gas, it's the pipe. In my respectful submission, the case is that simple. Now, I'll come on to address some of
the problem is neither the gas nor the pipe, it's the combination of the gas and the pipe.
Well, it's I don't accept that. I think the problem is the gas. The gas always has the potential to...
That's not what the FTT found, is it?
Well, if I can just take you to my skeleton. If you see at paragraph, page 46 of the bundle, this is tab 4. Page 46 of the bundle, it's paragraph 18. I just invite you to read that in the footnote.
Yes.
The FTT did was find that the land was contaminated on the basis of the gas. What it didn't resolve was whether the pipe was a substance within the meaning of the legislation.
But I'm looking at paragraph 12, subparagraphs 11 and 12 of the FTT on pages 96 and 97. So on page 97, they say the main problem with iron pipes is their potential to fracture.
Yep.
The gas which flows through the pipes does not increase the risk of fracture or cause or contribute to corrosion. And then in the next subparagraph, iron pipe remains in the ground, risk associated with have been reduced. In other words, the iron pipes themselves pose no risk. It's the presence of the gas which in those pipes which does. So it's the combination, isn't it, of the pipes and the gas which causes the risk.
Yes, I accept it's the combination of the pipes and the gas which creates the risk, because if it weren't for the pipes, the gas wouldn't be there, I suppose, on that basis.
No, and if it weren't for the iron, then the gas would not be the same risk. At any rate, you may say it was a slightly different risk, but
Well, if take a different situation, let's say this gas wasn't being pumped through a piece of infrastructure, it was sort of naturally occurring in the land, and it had the potential to bubble up. No one would be saying the gas by itself isn't a problem. Of course, the gas is a problem because it could be an offence to the senses of, leaving aside the fact that it's flammable. So, I don't. What Mr. Peacock is trying to advance is a case where the problem is only the pipe, and it's not the gas. He says that in terms really, or the actual cause of the contamination, in paragraphs 30 and 32 of his skeleton. That is just a surreal submission to make in circumstances where the pipe by itself, as you say, isn't a problem if you just carve it out and leave it in the ground. The problem is the gas escaping. And why is that a problem? Because the pipe is corroding, and that's because iron, particularly forms of iron, are susceptible to corrosion. But ultimately, it's the failure to contain the gas, as opposed to what it is which is failing to contain the gas. If one looks at the Transco case, one can see that pipes are made up of a variety of substances, including asbestos, it seems, for some periods. It doesn't really matter what the pipe is made of. It could be HDPE and there's a landslide and the gas escapes. So the problem is still the gas. It's not really the pipe.
So if we look at 3.
What makes up the pipe?
If we look at 3, paragraph 3.
Yep.
Land in a contaminated state, if and only if it's in such a condition by reason of substances in or on the land, that harm is being caused or the possibility of harm. Are you saying that land going through plastic pipes, the highest quality, highest standard, would still give rise to land being in a contaminated state if gas is going through those pipes?
Yes, because there's still a possibility of harm.
I see. So any remote possibility doesn't. A fanciful possibility that flies out of the window when you look at it and all that sort of stuff, it doesn't matter. The slightest possibility gives rise to land being in a contaminated state.
Well, possibility isn't qualified, is it? So it's
so you're
a
dread.
possibility.
I mean, if and only if. That would.
The evidence before the FTT wasn't that there was a tiny risk. The evidence was the risk was significantly reduced. That was the evidence before the FTT. That's the evidence we have. I can take you to the witness.
No,
if you like.
I'm just testing your argument.
so
That it's the gas.
so it would remain on your argument, the land would remain in a contaminated state, but leaving aside condition 6 for the moment, the purpose of the expenditure would not be to prevent or remedy the harm, it would be to minimise or mitigate the effects of the harm.
Yes.
So to use Mr. Peacock's phrase, it's a partial cure.
It's a partial cure, and inevitably, in the real world, I imagine most cures are partial in the context of when one's dealing with a definition of contamination which is so weak.
Yeah.
I think that must follow.
Well,
Unless it's a very discrete thing that there's, I don't know, something horrific in a box and you just take the box away or something like that.
or removing hydrocarbons from ground. I mean, that,
If you dig confidently enough that you're sure there's nothing else after testing, yes, maybe that would be a complete remedy. Yeah. So, I mean, just returning to where I see Mr. Peacock's submissions, he's making sort of a three-limbed argument, all of which are slightly interlinked. The first is that there's this purposive interpretation, which requires 12.4 to operate sensibly, well, it all depends what one thinks sensibly means. If it's that 12.4 has to operate so that gas companies can make claims, I'm not sure where that purposive interpretation, the purpose for that is derived from. It's certainly not from the words of the legislation. There's no other material. The second proposition, which is more focused in his skeleton than his oral submissions, is that when one is looking at the purpose, you're trying to find the culprit for and punish them or deny them relief if they are the responsible for the actual cause of the contaminated state. And the actual cause of the contaminated state is the pipes. That's paras 30 and 32 of his skeleton. And then the third proposition is this idea that a state of contamination is a binary question. Because that's key to his idea of all we're doing is continuing a state of affairs in place as opposed to making it worse, for example.
Why do you say the second is to punish? Isn't his point that it's to incentivize cleaning up a mess and reducing the risk of
the purpose of the
reducing the risk of harm?
The purpose of the schedule is undoubtedly to do that. The purpose of paragraph 12.4 is obviously to deny relief.
Yeah.
He says it expresses the polluter pays principle.
Yeah, but what does the polluter pay principle mean, and where is that evidence in the legislation? It's obviously a framing of it, but the way Parliament has chosen to frame it is obviously different than in environmental law because of the way of the words it's used in this context. So I'm not sure invoking some freestanding, ill-defined idea in another area of law allows you to ignore the choices Parliament has made. And for example, Parliament hasn't used the definition of pollution from environmental law. It's come up with its own coinage of contaminated state here. So I'm not sure how helpful that's.
What is the principle behind 12.4?
The principle?
If it's not the pollute that if you've polluted, you don't get if you're responsible for the pollution in some way, you don't get the relief, the extra relief.
I've got no objection with that formulation, my lord, but the question is, what is the meaning of responsible, I suppose, in that context? That's really what this whole argument is about. There's no question that the person who is responsible for the presence of the gas in the pipes at the point of remediation is obviously Mr. Peacock's client.
Yeah.
He just says that's not a relevant responsibility, I suppose, because that's been going on for time immemorial, subject to people turning off the gas every now and then. I mean, that's really the question posed, I think, by his submissions. And in my respectful submission, there's nothing in paragraph 12.4 which permits you to ignore what is a straightforward application of the words purposefully construed if you want, but to the undisputed facts here.
Yeah.
So I do say that one has to be cautious about just invoking ideas such as polluter pays. One has to consider what the definition of contamination is within the schedule and then the steps Parliament has taken in paragraph 12.4 constraint. And to be clear, we say you ask in 12.4, you ask what the state of contamination is at the point of expenditure, because after all that links back to paragraph 2. And so that obviously takes into account the actions of NGN in pumping the gas, as well as obviously its predecessor, NGT.
Yeah. Can
Can I just then address this question about the level of contamination? It wasn't really advanced in oral arguments, but it is sort of part of Mr. Peacock's submissions in his skeleton. And we would say that in terms of paragraph 3, that's quite clear that it's only concerned with whether land is or is not contaminated. And it certainly doesn't say how badly contaminated it is, for example, try to suggest levels. But since the test in paragraph 12.4 is concerned with the state of the land at the point of the remediation is carried out, one is asking the question of whether it is in a contaminated state at the point in time as a consequence, wholly or partly, of anything done, etc. So if one had a situation where the land was acquired in a state of low contamination, that would obviously be contaminated land for paragraph 3 purposes, and it would remain contaminated land. But if the owner then made it worse and then claimed remediation relief, that would be refused, because if you're asking the question, what is the contaminated state at the time of remediation, is the new owner responsible in whole or in part for that? The answer is clearly yes. And I think Mr. Peacock accepts that at paragraph 30 of his skeleton, since he accepts that where a claimant increases the contamination, even though he says there's no such thing as a level, at the same time he says if you increase the level of contamination, then that disqualifies you from relief. But that appears to be in tension with the idea that, well, if you just have a constant situation and you continue it, that's essentially a nothing for the purposes of paragraph 12.4. That's a key part of the submission. But what that misses is the state of contamination can only, in these unusual facts at least, can only
Sorry,
be
say that again?
the state of contamination can only be maintained by Mr. Peacock's clients. Sorry, the state of contamination can only be maintained by virtue of the fact that NGN has continued to pump the gas. And the legislation isn't concerned with whether you've continued an activity. It's simply asking the question, the land is, on the basis that the land is in a contaminated state at the point of remediation, who is responsible for that? And if you've sustained it, maybe that's a more accurate way of framing it rather than just mere continuation. If you've sustained the level of contamination, that is going to be enough. There's no reason to assume from the words that Parliament has used that that's going to be excluded. So it's a deceptively simple 4 lines of legislation. For the revenues part, neither the facts of this case nor the words themselves invite the sort of soul searching which Mr. Peacock is asking you to engage in. It's a straightforward.
Soul searching in tax cases is not a common activity.
Well,
For the lawyers or for the judges?
for the taxpayer.
But there are limits to, self-evidently, there are limits to how one can garner a purpose from a legislative regime, especially one which essentially emerges in a vacuum such as this. Yeah. And one simply just has the words to read. Yes, you have to avoid absurdity. Is the result here absurd? In my respectful submission, no, it is not. So that really is.
That's your case on condition 6.
Yeah, that's the big point in the case, really. Yeah.
Right. All right. Where do we go from here?
I think from here, shall we go to condition 4?
Right.
So I think for condition 4 to work, you have to accept that the pipes are not land, which, as I say, was common ground before the FTT and the UT.
Why do you say that? Why do you say that?
On the basis of the Woolstanton case and the...
No, so why do you say for condition 4 to work, you have to accept they're not land?
Because the dispute on condition 4 is whether expenditure is on land.
Yeah.
And so what the revenues case below was distinguishing was the Upper Tribunal said there has to be some nexus with the land in order for it to qualify. That in itself probably is an unambitious proposition. So for example, the sort of extreme example I gave, I think, in the FTT was, let's say one has a license to use a car park, and you park a particularly unreliable car which is liable to explode, for the sake of example. Or on any view, enough of a nuisance to satisfy paragraph 3. You then take some steps to repair the car in situ, for the sake of example. And the question is, well, what have you done? Have you repaired the car, or have you carried out expenditure on land? The answer, self-evidently, I would say, is you haven't spent anything on the land. You've just repaired a car. Now, the decision obviously different, at least presentationally, because the pipes are underground. But the key question is, are you spending money on infrastructure, or which doesn't form part of the land, so you have to accept that premise, or are you expending it on the land? That's really what the revenues case is on condition 4. And the question is, what degree of nexus is required? And Mr. Peacock, obviously...
Might produce some slightly odd results, there might. I mean, I'm discharging some pollutant into a drainage ditch, let's suppose. And there is a real risk of it getting into the aquifers.
Yes.
So I lay a pipe along the drainage ditch to contain the pollutant that I am discharging. Or I concrete the sides of the drainage ditch in order to stop the pollutant getting out. One wouldn't expect those to have different tax treatments, would one? In either case, what I'm trying to do is to protect the land from my pollutants. In one case, possibly by installing a chattel query. In the other case, by constructing something on the land. Why should the tax treatment of those two things be different?
On that example, I wouldn't suggest they necessarily would be, because there's a big difference between installing or using a chattel to carry out expenditure on land, as opposed to repairing or maintaining an existing piece of infrastructure, which doesn't form part of the land.
But it's for the same purpose, to stop the risk of gas escaping and causing damage to the land and anyone on it.
I would accept it's for the same purpose, yes, I don't dispute that.
So it's to protect the land in the same way that my lord's pipe protects the land, in the same way that his concrete protects the land.
Indeed. But there also has to come a point, taking my car example, that's clearly a chattel on the land. Yeah, and you could say the petrol in its tank is substance in, on or under the land. And you're trying to stop that causing harm. I don't think anyone is going to suggest that that is qualifying land remediation relief, simply because you've got a license to use the car park. So there has to come a point where you say, and it's maybe a matter of judgment, but you have to say, no, that isn't qualifying expenditure on the land, and that is, after all, what the FTT did. And indeed, the Upper Tribunal agreed with that, albeit.
What do you say to Mr. Peacock's characterisation of the structure of paragraph 2?
I certainly accept that the word "on" in paragraph 2, subparagraph 2,
yeah,
has to be different from subparagraph 4, yes. Because one is talking about essentially a head of expenditure, isn't it?
yes. So you do accept in relation to under 2.2 or not?
So I certainly would accept that if you use employee costs or materials and you satisfy whatever nexus has to be satisfied for the land, that would qualify, even though. So when you say on land, you're not comparing that with on employee costs. Employee costs and on materials can both contribute to expenditure on land. I don't dispute that at all.
I mean, as a matter of common sense, which may not be a good guide to these provisions. If you are repairing the pipe, the only reason you're repairing the pipe is not to have a better pipe, is to get rid of the risk. I mean, if one looks at the whole purpose of 30/30, etc., and the risk is on the land, which is why you're doing it. So isn't that a nexus? If what you say is right, that you do require a nexus.
Well, it's difficulty on this case is the land right of the gas company is quite an ethereal one. It's simply a right to access the pipe. And I accept that when one is looking at sub 2, one is not looking at that property right.
It's the more general land.
It's the physical land.
Yeah.
And so when one is asking the question, you are under a statutory obligation or regulatory obligation to repair this pipe for the purposes of your gas distribution business. You've got two things before you. You've got, obviously, well, three things. You've got the physical land, you've got your right of access to the pipe, it's your land right, and you've got your ownership, on my assumption, of the pipe itself. And you're carrying out all of this expenditure to improve the operation of the pipe and to stop leaks, for example. That is a matter for the FTT to assess as to whether the expenditure is on the land or on the, because it can't, you have to remove the candidate of the property right. The only two things you're asking the question of, in my submission, a binary question, is it on the land or is it on something else? And the something else in this case is the gas infrastructure network, which on my hypothesis isn't land.
Well, if the pipe remains a chattel,
yes,
and you are simply lining the pipe and posing the question, is that expenditure on land? Well, in a rather narrow way, I can see the answer is no. It's expenditure on the chattel. It may be that the same would apply if you are removing the old pipe and putting in a new one, assuming it remains a chattel once you've put it in. But in either case, the purpose of your expenditure is to stop escape into land. No other reason for doing it. Well, it's not being suggested, for instance, that it's costing the gas company money through leakage of gas, that it's keeping its expenditure. It's all done.
No, I'd accept the 30/30 programme is
it's all being done in order to stop escapes.
Either damage to people or to
property. So it's, if the question is this in relation to land rather than on land, which is where Mr. Peacock starts from, you may get a different answer even if they are chattels.
You certainly can't. I certainly wouldn't say the mere fact you expend money on a chattel that isn't the test. But it is obviously a matter of judgment, I would say, for the FTT as to applying that statutory test of what is the true nature of the expenditure.
Right. So you say this is an evaluative judgment for the FTT. It's in the nature of a fact-finding exercise and can't really be interfered with by a higher tribunal, or indeed this court, unless it's an unreasonable evaluation.
Well, no, Mr. Peacock would say that the FTT's just misunderstood the law when applying it to the facts. So I think I'm not going to try and shut him out on an ibus impersto. But I'm just saying, as a matter of practicality, it is something which one just has to consider and apply. Just hasn't been picked up, but it's a point I spotted. If one pops to paragraph 12, and to sub 1, there's a third formulation, which is in C, it has to be in respect of land. I'm not sure that adds anything, and it must be tautologous, because in order to have qualifying land remediation expenditure, you already have to have satisfied it, the test on land, for example. But it doesn't show a firm grip, if I'm being polite, that the draftsman of this legislation was necessarily using consistent.
I think you both agreed on that.
But I just wanted to draw that to your attention because that's
And on,
yes
on
another.
that happy note, is that an appropriate moment to adjourn?
Maybe that is. Yeah.
2 o'clock.
Not going to be very much on it, so. Just my substances.
Realize how much more